Management Association of the Philippines.
Okay. Good afternoon.
Good afternoon, Rene.
Okay.
Good afternoon, Rene. Good afternoon, everyone.
Good afternoon sa inyo lahat.
Good
Okay, let's
afternoon,
start.
everyone.
I'll start now. PMAP, in its commitment in advancing Filipino human capital through sound people management, has been at the forefront of pushing for fundamental work practices that benefit not only the people, but the business as well. However, as businesses have been disrupted by the COVID-19 pandemic, how are we then going to navigate with the new normal? Good afternoon. I'm Rene M. Henner, PMAP Executive Director, and I will be your moderator for this afternoon's webinar, entitled Reopening the Workplace, a Legal Perspective, which is hosted by the People Management Association of the Philippines. As we are physically distant due to the imposed enhanced community quarantine, we are seeing each other in the digital world. On that note, in case of technical difficulties, please forgive us and bear with us. For the past weeks, we had about 40 plus webinars with a total of 18,486 Zoom registrants, and we have a weekly reach of 535,000 plus people and 147,000 plus YouTube live views. Since many signed up for this webinar, Zoom application can only accommodate 500 participants. Nevertheless, you may still watch us via PMAP's Facebook. If you cannot access the Zoom link, please go to YouTube and hit the subscribe button. You can type People Management Association of the Philippines or search for at PMAP 1956. In case you will have questions, you may send it to us using the Zoom chat box, or those watching on Facebook, please post your questions in the comment section, and our staff will take care of forwarding the questions to our panelists. Kindly note that presentation materials are one of the perks of being a PMAP member. For PMAP members who wish to have a copy of these slides, and for non-PMAP members who wish to be a member of PMAP, kindly send an email to rhea.paragas@pmap.org.ph. At this point, I am delighted to introduce to you our esteemed speakers from Quisumbing Torres Law Office. Our first panelist is a partner in the Employment and Dispute Resolution Practice Group. He has 18 years of experience advising clients on general employment issues, employee termination, executive compensation, benefits transfers and terminations, and labor litigation. Named as the Distinguished Practitioner for Labor and Employment by Asia Law Leading Lawyers 2020 and Leading Individual in Employment, the Legal 500 Asia Pacific. Join us in welcoming Attorney Jon Zuniga.
Thank you for the kind introduction, Rene. Good afternoon, everyone.
Our second discussant is also a member of the Quisumbing Torres Employment Practice Group, advising clients on general employment matters. Prior to joining Quisumbing Torres, she worked in a law firm specializing in maritime labor law, representing protection and indemnity clubs in China, Greece, Japan, Korea, Norway, Sweden, and the United Kingdom. Let's all welcome the international lawyer, Attorney Roe Anuncio.
Hi everyone, good afternoon. Thank you, Rene, for that introduction.
Thank you. To help us in making this discussion relevant in industry's practices, we are also honored to have the Labor Relations Manager of San Miguel Corporation, having over 30 years of experience in human resource management and labor relations across the San Miguel group of companies. Attorney Noel Balsicas.
Good afternoon, everyone. Thank you, Rene, for the kind introduction.
Thank you. And joining us as a panelist direct from Bayao City is the 2019 PMAP Baguio Chapter President and Moog Controls Corporation HR Operations Manager, Mr. Rick Bayao.
Good afternoon, everybody. Greetings from the city of Pines, Baguio.
Okay. To start our discussion, I now give the digital stage to our speakers, Attorney Jon Zuniga and Attorney Roe Anuncio. Take it away, guys.
Thanks, Rene. So ako muna siguro mag-start for our presentation today. No? First, I'd like to greet everyone a happy DCQ. For those of us who are in the NCR region, sa Laguna, and I think sa Cebu City, no? If I'm not mistaken. For the others, I understand from the press briefing kanina, they were transitioned already from ECQ to GCQ. For the others naman, na-lift na yung community quarantine. With that, I think we may have different appreciations of the information that will be discussed today. But I think overall, whatever will be discussed today will be helpful to everyone, especially to you, to our audiences today, who are HR practitioners in assisting their employers, of course, and the employees in the companies to reopen the workplaces eventually. I'll just share my screen for the presentation. I'll turn off my video na lang din pala muna so we can all focus on the presentation. Okay, so for this part of the presentation, we will be discussing the major employment issues on resumption of operations. To start off, these are the questions that we would like to present to you. Kasi primarily, these are the basic questions that you should be able to address in order to assess yung preparedness ng company in reopening the workplaces. This is in line with the interim guidelines also that were issued by the DTI and the DOLE recently for purposes of reopening the workplaces and preventing and controlling the COVID-19 infection in these workplaces. These are the topics that we will be covering for this presentation. So maghahati kami ni Attorney Jon dito. For my portion, I will cover the compliance to national government regulations, I understand there may also be local government regulations that will be implemented by the respective LGUs, but we will not be covering that because it will vary from LGU to LGU. No? Second, the policies and guidelines on preventive health measures that are required or mandatorily imposed upon employers to be implemented in the workplaces, the tracking and reporting of COVID-19 cases in the workplace, and telecommuting or working from home as an alternative work arrangement. For Attorney John naman, he will be covering flexible working arrangements, the leave entitlements, benefits, forced leave or temporary layoff, which are flexible working arrangements that may be adopted by employers, business continuity plans, workforce communication and consultation, as well as measures to mitigate litigation for the companies. So let's start off with the interim guidelines issued by the DTI and the DOLE. These guidelines primarily, they provide for physical distancing measures and preventive health measures that are required to be in place in the workplace prior to the reopening. This is to prevent, of course, COVID-19 infection amongst workers in the workplaces and to control the spread. So these are the main points of the measures that are required to be adopted by employers in their respective workplaces. So the first is to provide information about COVID-19 to employees. Primarily, siguro you'll include there what COVID-19 is, how it spreads, ano ba ang symptoms ng COVID-19, and meron na bang vaccine, so wala pang vaccine, and then the cure or what are supposed to be done pag may COVID-19 infection. Water, soap, and sanitizer are available in all washrooms and toilets. In relation to this, the interim guidelines provide na before entering the workplace, lahat ng employees, workers, even the employers are supposed to spray alcohol or sanitizer before they enter. A foot bath in the building entrance na dapat dadaanan ng lahat ng papasok sa building. All work areas and frequently handled objects, let's say mga doorknobs or the elevator buttons, they should be disinfected regularly. Soap and water should also be provided in all washrooms and toilets. And sanitizers in corridors, conference areas, elevators, stairways, and all areas where workers pass should be provided also by the employer. For the third one, avoid or reduce direct exposure of employees to animals, environments, and objects which may possibly be carrying COVID-19. So this is also a responsibility of the employer to ensure na hindi makakakontak ng COVID-19 infection yung employees from these sources. Next, ensure that food in canteens or similar areas is properly prepared, handled, and cooked. In relation to this, in relation to the canteen areas or communal areas, the interim guidelines provide that eating in communal areas such as canteens or cafeterias in the workplaces, no, they are discouraged. But it also takes into account that if there's no choice, such that the workplace is not spacious enough or is not conducive to eating, and meron talagang canteen that is designated for eating, pwede naman silang i-allow na gamitin yung canteen or communal areas for eating, provided that the chairs and tables are disinfected after every use, and also disinfected at the start and at the end of each day. This is to ensure na kung ano man yung mga virus na naiwan doon, syempre, hindi na siya mata-transmit from one person to another who will be using the same chairs and tables. Also, the canteens and kitchens should also be disinfected regularly. Number 5, emphasize to all employees the everyday actions to stay healthy and keep a clean workplace. So, ano ba itong mga everyday actions that will ensure them or that will keep them healthy? Eat properly, sleep sufficiently, exercise regularly, And also, the interim guidelines also provide that the employer should provide free medicines and vitamin C to the workers. So that's an additional responsibility of the employer. The next one is to monitor the health of employees. So paano ba i-monitor yung health ng employees? So according to the guidelines, there should be a daily symptom questionnaire that is supposed to be accomplished by all employees sa entrance pa lang ng building. So prior to their entry to the workplace, they should accomplish this already. And also at that time, prior to entry, their temperature should also be checked and recorded in the daily symptom questionnaire. Additionally, employers are also required to provide for referral of workers who are needing counseling or presenting with mental health issues. So I think this takes into consideration now with the prolonged ECQ and the COVID-19 crisis, na-affect na rin talaga ang mental health ng employees. I think everyone, employees, employers, they're all affected mentally. So the employers are also required to provide or to extend help to their workers in terms of their mental health issues. Okay, so ito yung main theme for the interim guidelines, the physical distancing within the workplace. Ano bang ibig sabihin ng physical distancing? So it's a 1 meter distance sa side, sa back, and sa front in between employees while they're in the workplace. So this is also the reason why eating in communal areas such as the canteens or the cafeteria is highly discouraged because it would be difficult, lalo na kung sabay-sabay yung mga lunch breaks or merienda breaks ng mga employees or coffee breaks, no? Talagang mahihirapan i-implement yung yung physical distancing. So kaya din siya discouraged. Aside from that, in enclosed spaces such as rooms, halls, and even in elevators, required na i-observe ang physical distancing of 1 meter radius. Other pointers. Regulating in-person interactions. So, paano i-regulate ng employer ang in-person interactions in the workplace? First is to implement alternative work arrangements. So, possibly what we also do now during the ECQ, which is allow employees to work from home. Aside from that, employers can also implement rotation of workers or shiftings para hindi lahat ng employees in the workplace or in the work areas all at the same time. That would make it difficult to implement the physical distancing. Aside from that, face-to-face interactions are also discouraged. So if hindi maiiwasan yung face-to-face interactions, it is required that the employers or their employees and the clients who would come to the office should always wear masks. Another thing is that meetings are limited to a minimum number and duration. So as much as possible, kung kaya virtually gawin yung meetings like video conferencing, yung via Zoom, Skype, mas nire-recommend yan na gawin na lang to minimize any in-person interactions. Next, physical workplace modifications. So anong pwede nating gawin sa work areas ng mga employees to implement social distancing and to prevent contracting COVID-19 from one employee to another? First is yung mga office tables. So we can arrange the office tables in such a way na merong 1 meter distance if the space is if the workplace is spacious enough, no? Or other than that, we can also put up barriers in between, let's say, cubicles or in between workstations to prevent direct contact. The interim guidelines also provide for yung unidirectional movement in aisles and corridors para din organized yung flow of or movement of employees in the workplace. Next is to train employees on physical distancing and health measure policies. So it would be good for the employers to consider a meeting with the employees where they can be trained on how to implement social distancing or physical distancing within the workplace, and how to go about the health measure policies that are in place in the office. So important to para aware lahat ng employees even before the workplace is reopened or even before they come to the office. Employers should also consider regular screening protocols for employees, contractors, and their personnel, clients, and other workplace visitors. So as I've mentioned earlier, there's a daily symptom questionnaire that is required to be accomplished by all persons who should be entering the building of the workplace. It should be accomplished before entry and submitted to the guard or the safety health officer designated for COVID-19. Aside from that, my temperature check and yung temperature na nag-register would be recorded in the questionnaire as well. Also, the employer is required to provide for an isolation area that is disinfected, of course, within the workplace for those who register to have a fever or if they have certain responses or answers in the questionnaire na kailangan ng further evaluation by the clinical staff. No, kailangan muna silang ilagay sa isolation area and make sure na okay na talaga sila or wala nang any dispute or conflict with their responses to the questionnaire before they are allowed to enter the building. This is to ensure na they are not able to spread or transmit the virus if they have it to those who are already in the workplace. Also, the use of personal protective equipment should be required in the workplace. For all workers, they are required to wear masks all the time while they are in the workplace, except only when they are drinking or eating. This is required for all workers, no, regardless. And dapat itong mga masks are provided by their employers. And actually, the interim guidelines provide that the masks to be provided by the employer should be an appropriate mask. We know na mayroong mga different kinds ng masks na available now, no? So I think it is emphasized in the guidelines that it should be an appropriate mask. Aside from that, the employer is also required to provide medical grade PPEs to the clinical staff. Here are other considerations naman for the employers in reopening the workplaces. So these are practical concerns that all employers should take into consideration. First is bringing back employee access to employer systems. So during the ECQ, maraming employees na hindi nag-stop mag-work or nag-work from home. And for those na nag-work from home, maybe na-limit yung access nila to the systems of the company kasi syempre yung confidentiality of company information and other data security concerns are in place. So pag nag-return na sila sa workplace, this should be addressed by the employer to ensure the smooth transition from a work from home arrangement to a work in the office arrangement. Another one is the business expense reimbursements incurred during the community quarantine. So the employer should be able to address what obligations, if any, it has with respect to these expense reimbursements. Should they be allowed? Should they be paid to the employee? What are the rules and what are the policies that govern this issue? Next is the recovery of equipment and files that employees took home during the community quarantine. So para makapag-resume sila ng work in the office, kailangan ibalik yung mga equipment and files. So in terms of returning them in the office, this should also be properly identified in terms of procedure and how to do it, no? Para smooth din yung transition. Aside from those, the tracking and reporting of COVID-19 cases is also provided for in the interim guidelines of the DTI and the DOLE. Ano yung sinasabi ng guidelines regarding this? So they do not impose specific tracking requirements, but they provide for certain procedures kapag merong suspected or confirmed COVID-19 case in the workplace. Primarily, so earlier I mentioned that there should be an isolation area where workers or other individuals who wish to enter the building of the workplace should be placed kung meron silang fever or other questionable responses to the questionnaire. Aside from that, if the employee is suspected or confirmed of having COVID-19 infection, so kailangan i-report ng employer yung worker to the DOH and the local municipal or city health officer. So after that, the DOH or the local municipality should be the one na mag-aasikaso on what to do with the suspected or the confirmed case. Aside from that, the employer should also arrange for the transport to the nearest hospital of any suspected case for testing. So dapat ideally meron na ring policy on how such cases should be transported to the hospital. Pag may na-confirm na COVID-19 case within the workplace, there's also a procedure provided under the interim guidelines. So the workplace has to be decontaminated, and during that period, the work should be suspended. So papauwiin muna lahat ng empleyado para i-contaminate yung workplace. Now, after the decontamination, 24 hours after that, pwede na mag-resume ulit yung work. For those workers who were in the same area as the confirmed case, they are required to undergo a 14-day quarantine period. Now, if the suspected case is tests negative after the test, so the co-workers may now resume to their work, go back to the office and resume their work. Now, hindi naman nire-require ng government that employers have their employees tested for COVID-19 before resuming work or before coming back to the office. So, but then, the government allows employers to conduct mandatory testing of their employees. So, it's up to the employer kung itatest ba nila muna yung mga workers before allowing them to resume work in the office or not. But if they do decide to have their employees tested, they should be the one to pay for the tests. So the government will not give any subsidy or will not shoulder such tests. And if they so require, dapat meron tayong company policies or company policy that will govern the testing. Later on, I'll discuss more about that company policy. But aside from that, there are other considerations that the employer should take into account if they decide to have their employees undergo testing, such as the training of personnel, who will conduct the test, where will it be conducted, data privacy concerns, and yung coordination with the government in monitoring the test results. So let me just give you an outline siguro of the primary duties of the employer in connection with the prevention and control of COVID-19 infection in the workplace. So first, the employer is supposed to come up with a company policy on the prevention and control of COVID-19 in the workplace. So the company policy should be formulated in consultation with the employees. Aside from that, there should be a company policy on the conduct of the testing should the employer decide to have its employees undergo mandatory testing before coming back to work. This specific policy on the testing should be agreed upon by the employees. Second, the employer is required to provide resources for a safe workplace. So they're supposed to provide soap, sanitizer, alcohol, As I said earlier, yung masks and PPEs for the clinical staff, and also the testing kits should they decide to have the employees undergo mandatory tests. The interim guidelines also provides that the employer should enhance the health insurance coverage or provisions of its employees, taking into account possible COVID-19 infection. Another is the transportation or accommodation to be extended to the employees which is near the workplace, para na rin siguro to lessen the movement of workers from one place to another and to make it easier for them to come to the office. Additionally, there should be a safety officer specifically for COVID-19 measures. There should also be a COVID hotline put up by the employer to monitor suspected cases and to address any concerns or questions that employees may have in relation to COVID-19. And lastly, the employer is required to report monthly to the DOLE, copy furnish the DOH with respect to illnesses or injuries that happened in the workplace. Now, with the modified ECQ and perhaps for some na nasa GCQ na now, magko-continue pa rin itong telecommuting or working from home arrangements. In fact, under the interim guidelines, those who are the vulnerable groups, they call the vulnerable groups, quote unquote, should be allowed to continue working from home without any diminution in their wages and benefits. So, sino ba tong vulnerable groups na to? This includes individuals who are over 60 years old, so yung mga senior citizens, those with pre-existing illnesses, those who are immunocompromised, and those with high-risk pregnancies. So for these group of people, they should be allowed to continue working from home without diminution in wage and benefits. We may already be aware of this since some of us naman nag-work from home na, but there are specific guidelines for implementing telecommuting arrangements or work from home arrangements. Based on the DOLE Labor Advisory 11 series of 2020, so we should continue implementing work from home arrangements during the quarantine period to avoid the further spread of the COVID-19 infection. The procedure would be to consult the employees regarding the implementation of the work from home arrangement and get their agreement to work from home. We should also notify the DOLE prior to the implementation, and we should also post a copy of Labor Advisory 920 in a conspicuous location in the workplace. There are also, of course, other considerations in implementing telecommuting or working from home. So, for example, impact on supervision, work efficiency, communication, and staffing. For those who have been working from home during the entire enhanced community quarantine period, siguro na-assess na natin yung mga considerations na to, like how efficient have the employees been during the ECQ while they were working from home. Are they able to be supervised by their supervisors during this period? Other considerations would be requests for accommodation of certain employees, which is near the workplace. So as sabi nga dun sa interim guidelines kanina, employers should also provide for accommodations to employees, which accommodation should be near the workplace to facilitate their coming to work on a daily basis, no? And another consideration would be the requirements of other government agencies. So for example, for PEZA registered enterprises, they have specific requirements for working from home. So depende yan per agency. So if the company is registered with a certain agency, you may want to check their regulations or policies in terms of implementing work from home arrangements in the company. So with that, I'll turn you over now to Attorney Jon to discuss the rest of the presentation. Attorney Jon, naka-silent kaya naka-mute ka. Attorney Jon?
Mute si Attorney Jon.
Nga, naka-mute siya.
Okay. Hi everyone. Sorry, I'm actually connected through my phone for my audio, but it seems that I'm not allowed to. Well, I cannot use my phone for audio, so I need to use the internet connection. Apologies everyone because I have a slow internet, so that was why I wanted to use my phone. Anyway, I'll try to share my screen. If not, then maybe Jeff can just proceed to share the screen for everyone. Okay, so I'll start with the flexible work arrangements as mentioned by Attorney Roe. Ito yata yung problema sa ano, no, yung live tayo. Minsan merong mga technical difficulties that we cannot really avoid. Okay, maybe I'll just turn off my video in the meantime just to maybe lessen the bandwidth requirement. Can you hear me? Sorry, Rene, can you hear me?
Yes, yes.
I'm unable to
We can
click on the
also-
slides. Maybe Attorney Roe can help.
We can also see your slide number 5, flexible working arrangement. It's projected now.
Okay. So for flexible work arrangements, so in order to help employers and employees to cope with the impact of COVID-19 outbreak and the consequent implementation of this ECQ, so the Department of Labor and Employment has issued Labor Advisory Number 9, Series of 2020, which encourages employers to adopt alternative work arrangements. So ano-ano nga ba yung alternative work arrangements na to? Among others, there's this reduction of work hours or work days. For instance, before you used to work for 8 hours, then the employer can just reduce the hours to 4 hours a day because of the decrease in the workload. Pwede rin naman na reduction of work days. So from 5 days or 6 days a week, it could be 3 days a week. Now, another flexible work arrangement that is being encouraged by the DOLE is the rotation of workers. So kung konti talaga yung trabaho, imbis na mag-force leave yung ilang employees natin, maybe we can just do a rotation of workers. So for instance, in a week, we can ask the first group of workers to work for 5 consecutive days. And then after 1 week, they will be on leave. And then they will be replaced by the next batch of workers. So this way, everyone will still continue to be employed, although for reduced work days, but still will receive their compensation, although reduced, instead of just receiving nothing in the meantime. So that's why there's this related flexible work arrangement also of forced leave. Because in case of implementation of a forced leave, the leave credits of the affected employees, if there are any, should first be utilized. But if such leave credits are exhausted, then the employees will have to be placed on unpaid leave. Unless, of course, the employer voluntarily pays the employees during on forced leave, or even if there's no legal obligation to do so. In any event, the duration of the forced leave should not exceed 6 months, after which the employee should be recalled back to work or otherwise dismissed for authorized cause and paid separation pay in accordance with law. Ano po ba yung requirement bago tayo mag-implement ng flexible work arrangement? So among others, there's a need to consult the employees before such implementation. Does this mean that we need to get the consent of the employees? Not necessarily. Ang kailangan lang po i-consult natin, at least alam nila kung ano yung pwedeng mangyari. Baka naman meron din sila magandang inputs in connection with the implementation of the flexible work arrangements. The second requirement is that the dole should be duly notified about the adoption of the flexible work arrangement before the implementation. Meron po bang requirement na, for instance, yung sa redundancy, retrenchment, and other authorized causes for termination, di ba meron tayong 30-day prior notice requirement. Hindi naman po siya strictly applicable dito as long as the dole is duly notified. In fact, I think at this time they've been quite lax in implementing this notification requirement because they recognize the difficulties arising from the current ECQ that we are in. And lastly, a copy of the Labor Advisory 9-20 should be posted in a conspicuous location in the workplace. Pero kung wala naman sa workplace yung mga tao, pwede naman sigurong email na lang natin or padala natin sa kanila yung kopya ng Labor Advisory number 9-20. So aside from that, next slide please. The DOLE's Labor Advisory number 11 reiterates the adoption of flexible work arrangements as better alternatives to outright employment termination or complete closure of the business establishment. So yun nga po sana, the DOLE, the government is encouraging employers instead of just either forcing the employees to go on leave or letting them go by virtue of authorized causes to try to maintain their or secure their jobs by considering these other flexible work arrangements. Next slide, please. To further support the employees who are unpaid leave during the ECQ, employers have been encouraged to apply for the financial assistance granted by the DOLE under the CAMP program or under the Department Order number 209. Pero dahil nga po sa kakulangan ng budget, we understand that the applications for financial assistance has been stopped in the meantime. Mukhang wala pong sign na magtutuloy, pero meron pa pong isang programa yung gobyerno, yung Small Business Wage Subsidy, which also is meant to provide financial assistance to employees who suffer a reduction in income as a result of the implementation of the ECQ. Yung requirement naman po sa Small Business Wage Subsidy, the employee should not have been paid for at least 2 weeks due to absence or suspension because of the cessation of operations in the meantime arising from the ECQ. Next slide, please. Ano pa ba yung iba natin kailangan i-consider before reopening the workplace? Of course, we should be ready to address leave entitlements of employees who are unable to work. As I said earlier, currently, the absences of employees during the ECQ should be charged against the employee's existing leave credits. But the DOLE has asked the employers to exercise compassion, flexibility, and generosity, and are hoping that employers will pay employees even if they are not reporting to work because of COVID-19 related reasons. Pero syempre, kung mag-decide tayo na bayaran natin yung employees who are on forced leave or who are not reporting to work in the meantime, we should also be careful that the grant of these additional leaves will not set a precedent or become a demandable practice later on. So ito naman yung related natin na concept dun sa next slide natin, yung topic natin on benefits. We have received a number of queries from clients regarding the possibility of reducing certain employee benefits as part of cost-saving measures during the COVID-19 crisis. Pagka nag-usap tayo ng benefits, syempre kailangan natin maging aware dun sa concept or principle of non-diminution of benefits. Ano ba itong non-diminution of benefits rule na to? Ibig sabihin lang, the employer may not unilaterally take back or reduce an existing benefit which the employer previously had no obligation to give but has nevertheless voluntarily given to its employees. The reason for this is that this prohibition is that the benefit has become part of the contract between the employer and the employee by virtue of this established practice. Pero ano ba yung mga requirements bago magkaroon ng application ng non-diminution of benefits? Next slide, please. So first requirement, the grant of the benefit is based on a policy or has ripened into a practice over a long period of time. Ang usual question dyan, gano'ng katagal ba yung long period? There's really no hard and fast rule. Siguro ang titingnan dyan ng labor courts kung magkaroon ng issue sa non-diminution, kung consistent ba yung application such that the employees have relied or already has this expectation, which crystallizes into a demandable practice, that the employer will continue to grant such benefits. That's why there's this condition that the benefit grant is consistent and deliberate, and the grant, lastly, is not due to error in the construction or application of a difficult or doubtful question of law. So hindi dahil na misinterpret natin, for instance, yung regulations ng Department of Labor sa pag-apply ng leaves or computation ng salary, kung hindi, voluntary na binigay ng employer yung benefits sa mga empleyado, kaya nagkaroon ng demandable na practice. So, if the employer proceeds to reduce the benefits of the employees in violation of the non-diminution of benefits rule, then the employees may have basis to file a complaint against the company or the employer for breach of the employment contract and also for constructive dismissal. Meron naman tayong mga exceptions dun sa non-diminution of benefits rule. One exception is that if the grant of the benefit is subject to conditions and any one of those conditions is not met. Kaya importante po kung magro-roll out tayo ng benefits, malinaw din sa policy natin with the acknowledgement of the employees that there are certain conditions for the employees to be able to avail of these benefits. I can discuss this further later on. Another exception is that if the employee consents to the reduction, suspension, or termination of the benefits. Because after all, under the non-diminution of benefits rule, the employer cannot unilaterally modify benefits that have become demandable. So kung result naman ng voluntary agreement between the parties, then there is a cause for the employer to argue that there is no violation of the prohibition. So employers should analyze whether it can resort to reduction of benefits, for instance, allowances, as part of cost-saving measures. So for example, we have received queries on whether the employer can refrain from paying transportation or fuel allowances to employees who are not reporting for work or are working from home. Yung sagot dito sa question na to, depende yan sa terms and conditions surrounding the grant of such allowances. I can think of a couple of scenarios. For instance, in one scenario, the employer grants the employees the transportation or gas allowances regularly in fixed amounts and without need of substantiation. So in these instances, the employees may have basis to claim that the gas or transport allowance is a guaranteed benefit given by the employer, which is covered by the non-diminution of benefits rule. So in such a case, the employer may not suspend the grant of such allowances without the consent of the affected employees. On the other hand, pwede naman magkaiba yung scenario natin. Pwedeng yung grant ng transportation or gas allowance is subject to certain conditions. For instance, the submission of gasoline receipts or other similar documents and the presentation of proof of approved official business. So in this scenario, the employer may have basis not to grant the gas allowance to the employees if the employees are unable to submit the supporting documents. So for employees who cannot travel because of certain either ECQ or GCQ restrictions or are merely asked to work from home, then the conditions for the grant of the transportation or gas allowance will not be met. And the employer may discontinue the grant of the allowance or suspend the grant until such time that the conditions are already satisfied. So next slide, please. So another issue that should be considered during the reopening of the workplace is the possible temporary layoff of employees or even a reduction in force. So employers should consider when and how to bring back employees who were placed on forced leave or temporary layoff. As I said earlier, there's currently a limit of 6 months for temporary layoff. And in the event that there is still no available work after the lapse of 6 months, then the employer will need to really make tough decisions. Ano ba yung gagawin natin? Naka-forced leave na yung empleyado ng 6 months. So as I discussed earlier, The government encourages employers to adopt flexible work arrangements to try to preserve the jobs of their employees. However, there may be circumstances which may compel the employer to dismiss employees during the COVID-19 outbreak. So to preserve the business, employers may dismiss workers based on authorized causes under the labor code, such as redundancy and retrenchment. Sometimes these terms, yung redundancy and retrenchment, are used interchangeably. Kasi yung retrenchment, parang yung layman's term, ito rin naman yung pagbabawas ng empleyado. But actually, they have technical meanings under our law. There is redundancy when the services of an employee are in excess of the actual requirements of the business. On the other hand, retrenchment is resorted to primarily to avoid or minimize business losses. In both instances, the employer is required to establish good faith, or that the employer is letting go of employees to advance legitimate business interests and not just to defeat or circumvent the employee's right to security of tenure. So paano ba natin i-establish yung good faith? Next slide, please. So for redundancy, there must be adequate proof of the superfluity of the position, or that the position is in excess of the needs of the business. So based on Supreme Court decisions and also the implementing rules of the labor code, these documents could include the new staffing pattern, a feasibility study or proposal on the viability of the newly created positions, yung job description para mapakita na pwedeng i-absorb na lang, for instance, ng existing positions yung position that is considered redundant, and also the approval by the management of the structuring. So in short, the employer must be able to provide a business case for the redundancy termination, which should then be discussed and approved by the employer's decision-making body. Next slide, please. So for retrenchment, the employer must be able to establish that the dismissal of the employees is necessary to prevent business losses. And we are not talking about minimal business losses. So the employer must show that the losses are substantial, are serious, actual and real, or if only expected, are reasonably imminent. Usually, ang pinapakita po dito yung mga audited financial statements, which clearly show the substantial losses that are being suffered by the employer. So assuming that you're able to establish the necessity of dismissing employees due to redundancy, hindi naman pwedeng piliin mo na lang basta-basta, no, na arbitrarily kung sino yung tatanggalin. So for instance, you cannot just let go first of employees whom you think are most likely to be infected with a virus because of their age or health condition. Next slide, please. So at present, the Department of Labor provides for the last in, first out rule. Among the relevant employees should apply in selecting the employees to be separated, except when an employee volunteers to be separated from employment. So ano ba yung ibig sabihin ng last in, first out? So it means that when there are two employees occupying the same position in the company affected by the redundancy or retrenchment program, then the last one employed will necessarily be the first to go. This last in, first out rule is susceptible to a challenge because previously, the Supreme Court itself has recognized that an employer has the discretion to adopt other fair and reasonable criteria, or has the discretion to determine which employees are still necessary for its operations and which are superfluous. Ano ba yung mga dating nire-recognize na fair and reasonable criteria? So for instance, efficiency, performance rating, work skill, work experience. Pero itong last in, first out rule, parang naging restrictive, naging seniority na lang yung basis. So if the company is quite aggressive, it might even take its cue from the IATF, which seems to prevent or at least discourages persons with immunodeficiency, comorbidities, or other health risks from going out except when this is indispensable under the circumstances for work in permitted industries and offices. Pero ang problema po dito, dahil meron tayong last in, first out rule under the implementing rules of the labor code, and this has not been ruled upon by the Supreme Court yet. So ultimately, it will be the court which will decide whether a selection process that deviates from the last in, first out rule is valid. So next slide, please. Aside from the substantive requirements that I discussed, syempre kailangan din natin sumunod sa appropriate procedure for terminating employment due to redundancy, retrenchment, or other authorized causes. First requirement is that the employer should give individual written notice of separation to each affected employee and to the dole at least 1 month or 30 calendar days before the effective date of the dismissal. Dapat siguro ngayon i-take into account natin yung possible challenges aside arising from limitations on transport even during a general community quarantine. So allowances need to be made to ensure compliance with the 30-day notice requirement. Ngayong ECQ ba, may mga questions. Kung sarado yung dole, paano natin isasubmit yung ETR? Wala pong clear regulation tungkol dyan. Pero kung ang requirement naman is 30-day notice to the dole, maybe if we really need to dismiss, we can email the establishment termination report to the email addresses of the dole regional and field offices provided in their website. Pero di ba nga po sabi natin kanina, ini-encourage ng Department of Labor na last resort na lang yung dismissal. So kung pwede tayo mag-adopt ng ibang flexible work arrangements, for instance, habang tinitingnan natin yung sitwasyon, hindi natin alam kung talagang kailangan natin ng lahat ng empleyado natin o kung kailangan natin magbawas, baka pwedeng forced leave muna yung gawin natin. Ma-address din yan yung practical consideration ng pag-submit ng ETR sa Department of Labor kasi pwedeng naka-forced leave muna tayo habang hihintay tayo na i-lift yung ECQ at magbukas yung offices ng Department of Labor. Sa ganun, kung sakali mag-decide tayo later on na ituloy yung dismissal dahil wala tayong choice, then it's easier to submit the establishment termination report and comply with the procedural due process requirements for the authorized cause termination. So another requirement under the labor code is that the employer should pay separation pay to the affected employees. The minimum amount of separation pay is the employee's 1 month salary for every year of service, or 1 month salary whichever is higher in case of redundancy, or half month salary for every year of service, or 1 month salary whichever is higher in case of retrenchment. So pag ganyan, yung pag-compute ng tenure, fractional service of at least 6 months should be considered as 1 year in computing separation pay. Of course, the employer should give a higher separation pay if there is a contract or company policy or practice providing for a higher amount. We should also take into account allowances in the computation of the separation pay of the employees if the allowance is a fixed amount paid on a monthly basis without need of substantiation and not for business requirements. So in other words, if the allowances to be included in separation pay are those that are indeed part of the monthly compensation or salary of the employee, but are merely called as allowance for tax purposes or other reasons. Ngayong may crisis tayo, no, maganda na yung mga employers, kung kailangan talaga nilang magtanggal, magbigay sila ng mas mataas na separation pay. That, of course, is laudable. But for your protection, you should also take note of the risk of setting a precedent. So you can perhaps address this risk by clearly stating that the additional financial assistance for employees that you are dismissing at this time is really a one-time grant and subject to the absolute discretion of the company, depending on its assessment of its financial capacity. Lastly, pursuant to Dole Labor Advisory Number 6, Series of 2020, the separation pay and final pay of separated employees should be released within 30 days from the effective date of separation. Kung ano po yung exemption dyan, na-discuss po namin yan sa separate webinar. Basically, under the doctrine of Milan versus NLRC, pwedeng i-withhold ng employer yung final pay kung yung employee hindi nag-comply sa clearance procedure. For instance, meron siyang mga liabilities na hindi pa niya binabayaran. Another concern is the when we rehire after dismissing employees due to authorized cause, because the situation is quite fluid, no? Employees who may lay off employees, employers who lay off employees might have the opportunity in the near future to rehire laid off staff, bring on new staff, or both. From a risk management perspective, the safer option for employers is simply just to rehire the employees who were laid off. Rehiring laid off employees might make more practical sense too, because the former employees already know the employer's policies and procedures and are able to hit the ground running without a long onboarding or training process. So in general, rehiring laid off staff is thought to have a positive impact on workplace culture and counteracts any negative feelings caused by the layoff themselves. Kaya lang di naman din ganun kasimple minsan yung desisyon ng mga employer. For instance, if the layoffs were based on performance measures and the lowest performers being the ones who were let go. Likewise, changing business needs sometimes necessitate new skill sets to fill evolving roles. So in these and similar circumstances, employers might have good reasons to hire new employees instead of the ones who were previously laid off. But the employer should be aware of potential sources of liability when making these decisions. For instance, if a laid-off employee is replaced by a new employee, the former employee might perceive an improper motive in the dismissal. Hiring of replacements might indeed be considered as negating the reasons for a valid redundancy termination. Another scenario is one in which an employer lays off, for instance, 2 senior employees and 2 recent college graduates. And then the employer decides to hire back the 2 recent graduates or the junior employees because probably they earn the lowest salaries while filling the other 2 positions with new employees who earn less than the older employees once did. But this may create the perception that the younger employees are the hiring choice might create a perception that the layoff was a pretext just to dismiss the more senior employees because of their age. So to mitigate the risks from rehiring, employers should review their layoff and rehiring policies. So first and foremost, should be ready to establish the change in circumstances that justify a rehiring shortly after a redundancy termination. Employers should also speak to the managers who conducted the layoffs to explore if they perhaps inadvertently made any promises during the process. So in selecting employees for rehiring, employers should implement a policy requiring decisions to be based on objective and justifiable factors. Next slide, please. So another issue is the business continuity plans. So the sudden implementation of a quarantine last March has highlighted the need for companies to adopt business continuity plans. So a lot of employers were caught unprepared and had to scramble to distribute laptops, routers, or other equipment to give their employees work from home capabilities. Meron nga pong kwento nung isang HR manager na tinanong ng staff niya nung pag-implement ng ECQ dahil hindi sila makapunta sa workplace. So tinanong yung HR manager nung staff, "Sir, meron ba tayong business continuity plan? Kasi bigla na lang tayong nagsara, hindi alam ng mga employees natin kung ano yung gagawin." So confident naman yung HR manager, "Of course, meron tayong BCP." "O sige sir," sabi ng staff, "i-implement na natin." Kaya lang, doon lang na-realize nung HR manager na yung BCP pala nila, hindi niya kabisado, nakasave doon sa laptop niya, at yung laptop niya, naiwan niya sa opisina. Hindi naman sila makapunta sa office. So yung mga ganyang problema. So even with the impending lifting of the ECQ and the transition to a GCQ, we are not certain that there will not be a second wave of infections, just like what happened in countries that appear to have prematurely lifted restrictions to try to boost the economy. Next slide, please. So the 2-month ECQ has given you an idea of what could probably go wrong and the flaws in your company's respective business continuity plans. So it is important for employers to review, revise, and improve, if necessary, their current business continuity plans in order to respond to another potential outbreak of COVID-19 and any resulting government initiatives like another ECQ. So yung na-discuss earlier ni Attorney Roe, yung work from home arrangements, no, and Telecommuting Act. It requires the parties to put in place telecommuting agreements. So you might want to revisit your existing agreements or come up with such agreements if still have none before there is a need to again ask your employees to work from home. Next slide, please. So in a time of high anxiety, ngayon parang maraming na stress na mga empleyado, so mental health is also an issue. So kailangan tayong mga employers or HR or people managers, we should also try to assure our employees. It is important to remain in constant communication with employees as the workplace reopens so that employees know what to expect upon returning to work. In coming up with policies on the issues that we discussed earlier, you should take note that the Philippine Constitution recognizes the right of employees to participate in policy and decision-making processes affecting their rights and benefits. Sabi ko nga kanina, hindi naman kailangan lagi na yung inputs ng mga empleyado natin ay ipapasok natin doon sa mga polisiya natin. Ang importante, merong good faith na consultation and we try to get their comments or inputs, and then later on it's up to us whether it is worthwhile to include those inputs when we finalize the policies. So we normally recommend that before promulgating policies, employers should circulate the drafts to the employees and then give them a few days to give their comments or inputs. In any case, having these interactions with employees and giving them a sense of participation during this time of social or physical distancing may help boost employee morale. Next slide, please. So ngayon na may crisis tayo, syempre ang gusto natin pag nag-reopen tayo or when we restart the business is to focus on how to ensure that the business survives and preserve the employment of our workers. Minsan maraming distractions which might be costly because of, for instance, the litigation expense arising from labor cases and because we can't focus on our goal of ensuring the survival of the business because we have to address these labor complaints. We should remember that it's in reality, it's quite easy to file labor cases in the Philippines. Walang filing fees. Meron lang pong pro forma complaint form yung NLRC na checkan lang ng mga empleyado. Nandun na yung mga causes of action. Tapos in the meantime, they need not even engage the services of a lawyer during the mediation or conciliation proceedings. In fact, bawal nga po dapat yung mga abogado during sa conciliation. So napakadali na mag-file ng complaint. And once a complaint is filed and the case goes through arbitration before an arbiter of the National Labor Relations Commission, the employer has the burden of presenting substantial evidence to justify its actions, such as the implementation of a redundancy termination, for instance. And in case of doubt, the labor courts are duty-bound to rule in favor of labor. Tapos dun sa gastos ng litigation, meron din exposure in case of an adverse decision, which could also be substantial. This could include reinstatement, and under our labor code, reinstatement order of the labor arbiter is immediately executory, even pending appeal. So habang nag-aapila tayo sa Appellate Division ng National Labor Relations Commission, kailangan nating bayaran yung illegally dismissed employee in the meantime, either by actually asking them to report to work, or if you don't want them to physically report to work, place them on payroll reinstatement. So basically, they're on paid vacation while the case is pending. So aside from that, we can be held liable for back wages, damages, and attorney's fees. So employers should consider how to handle any potential employee claims that may arise from the measures taken during the crisis period. We should revisit policies to ensure robust mechanisms are in place to encourage reporting, conduct effective investigations, and address employee complaints. So that's the end of our presentation. Thank you very much, everyone. So maybe Attorney Noel and Sir Rick can provide their inputs and comments. And then afterwards, we can have a Q&A.
Thank you so much, Attorney Jon and Attorney Roe. At this time, may I beg the indulgence of Attorney Noel and Mr. Rick Bayao, because I have here with me about more than 40 questions from your listeners, no? And maybe, Attorney Noel, we can discuss your reaction as we go on, as we ask the questions. I'd like to break the discussion by asking some questions that are relevant to the presentations. The first one comes from Mr. Manuel Casimiro. The question is, are the Dole DTI guidelines translated as law that all must follow or otherwise be legally culpable? Or are they just that, guidelines for good management? And may I remind everyone, I got also a text that we have several expats listening to our webinar. So kindly, let's discuss in English. Thank you.
So kanino mo i-address yung attorney, Karine, is that for me or for Attorney Jon?
Any of the panelists.
I'd like to take that question. So insofar as the DTI guidelines are concerned, it's not merely advisory, it has the force of law. Remember, the Department of Labor has been given rule-making powers under the Labor Code. No? So the Secretary of Labor and Employment can come out with guidelines in the course of implementing the Labor Code. So you remember, if you recall, you have DO 174. It's the guideline, it's the rules implementing contracting and subcontracting the Labor Code. In the same token, that while there is no specific provision of the Labor Code that is being implemented here, but in general, this speaks of like what? It's talking of like health and safety workers. So the guidelines provided under the joint issuance of DTI and DOLE has the effect of law, so that if you violate those guidelines, then you can be held. The company can be held liable for that.
Okay. The next question comes from Jean Estueta. There are air sterilizers and filters in the market. There are also foot baths to disinfect footwear. Are these required?
I'll respond to that na lang, Rene. So dun sa DTI and DOLE interim guidelines, it provides for the provision of foot baths sa entrance ng workplaces or buildings ng workplaces. Pero yung sterilizers and what's the other one that
footwear.
was
Foot bath.
The foot baths are provided for in the interim guidelines. Pero yung sterilizers, hindi naman yun nakaspecify talaga sa guidelines. So up to the employer na lang if the employer thinks that for good measure, it will help in the prevention and control of COVID-19 infection in the workplace, then pwede rin nalang i-provide yun sa workplaces.
Thank you. The next question comes from Pinky Mante of Cebu. Please clarify if the provision of vitamins to employees is mandatory. If so, for how long?
Dun sa interim guidelines din kasi naka-provide dun that employers are enjoined to provide medicines and vitamin C's to employees. No, hindi naman specify talaga kung how long mag-provide. So I guess it's employers are encouraged to provide medicines and vitamin C's to the employees. Walang specify na period.
Thank you. Question number 4 from Lynn Villanueva. Is the employer required to test all employees for COVID prior to resuming work?
I'll take that question, Karen. Employee testing for COVID-19 is encouraged by the joint guideline. And as a matter of fact, I think it's a very sound policy because even if we have gone through quarantine for the longest time, for some maybe more than this would be like 75 days, but mostly 60 days. We have been on quarantine for 60 days. Yet there is no saying that after this, no one is anymore infected by the virus. Now, if an employee reports for work and is not tested, and if he is a carrier, then the possibility of him transmitting the virus to others is very high. And therefore, to make sure that workers are indeed healthy, and I think it is the right of workers to really know the state of health, their state of health. The testing should be mandated. The problem only in this particular case is that the testing is being charged against the employer. But you have to remember that the employers now are, have been down and out. They have been into so many valleys for the past days and the past weeks. They haven't really come up with a way to recover. And if you require them now to spend for the testing, then that would be, adding insult to injury. Now, let me just clarify it further. Each employee is a contributor to PhilHealth. That's an automatic deduction to our salaries. Yet, there is no benefit provided by PhilHealth right now, insofar as testing of workers are concerned. What is provided under PhilHealth rules is testing of symptomatic persons. But if you are not symptomatic, then you cannot be tested for COVID-19. Government has to remember that our workers are the primary drivers of our economy. And the only way for the entire country to recover is to have the best and the healthiest workers that we can have. If one company tests all of its employees, that would be useless because after testing, and by the time these guys go home to their families and they ride, commute the public utilities and all of that, then there is a possibility that they can be infected. They can be the virus can be transmitted by other workers who have not been tested. So my proposition is that testing should be a requirement, and it's not just a requirement, but it should be a right for workers. And I think that's something that government has to look into, especially in the aspect of shouldering the cost. The cost of commercial COVID testing right now is about 8,000 pesos. But if you go to Philippine Red Cross, I think it's 3,500. So if you are an earner, wage earner, you have contributions to PhilHealth, and I think you have the right also to be entitled to the benefits of that contribution. So being a worker, for that matter, I would insist on having myself tested. But I think we have to ask government to help us out on this one. Thank you.
Thank you.
Can I say something about that? I would like to second the proposal of Attorney Noel because in that manner, that is our way of supporting the effort of the government for mass testing. And we all know that mass testing is a good way of determining where we are in this crisis. Further to that, it is also a way for the government to support the private sector by at least subsidizing the cost of testing for workers. Although some are saying that testing of workers is only up to that date of testing because the moment that they get out of the workplace, they don't know what happened. But just the same, it is still best to have an actual testing, the reliable one, and we know the health status of our workers.
Thank you, Rick. There is also a question here regarding PESA from an anonymous attendee. Based on PESA Memorandum 2020-011, does it mean work from home is applicable for all PESA registered companies until July 31, 2020?
We are a PESA locator, and we have not, and we are in close coordination with the zone management here in Baguio. We have not heard of any advisory that is mandatory. First and foremost, work from home is not applicable in some companies like us in the manufacturing. We cannot bring our machines to our houses and do machining of parts there. So I would say that that is not mandatory. It's still dependent on the nature of operation of companies within the economic zone.
Thank you. There are so many questions here that I'm being saddled by. This comes from Ivy Rose Samson. This is question directed to Attorney Jon. In the matter of management wanting to reduce some of its benefits, would it be best to get the consent of employees per benefit, or it may be presented as one collectively presented to employees? Attorney Jon.
Thank you, Rene. There's really no hard and fast rule, but my recommendation, if we have a set of benefits that we want to amend, then might as well discuss it with the employees altogether. Kasi minsan, meron tayong i-reduce na benefit or yung ma-offset naman sinasabi natin doon sa increase ng benefits doon sa ibang items. So I think it's better, ideal for us, the employers, the HR managers, people managers, to present the package of benefits together to the employees so that they can make an informed decision on whether they will agree to the reduction of their benefits. And I think it's also important for the HR managers to explain to the employees the reasons why we are trying to implement these measures now. Because in reality, if the benefit is really a demandable benefit, then the employees may withhold their consent. So it's a matter of convincing them that this is actually a win-win solution to try to manage the cost of the employer at this time, but at the same time, try to preserve their jobs.
May I add to that, Rene, no? The biggest challenge now of businesses is really how to get back to its feet. A lot of businesses are losing clients. Hotels have no bookings. Airlines have no flights. Passenger buses have no, they don't have any trips. And so many manufacturing outfits are also out of commission as of the moment. The biggest problem is really how these companies will be able to get back on its feet, given that the process by which we are trying to recover is not immediate. Hindi siya biglaan eh. It's a step-by-step process, and along the way, it may take longer than what we think it is. It would take for the usual recovery of businesses. For all we know, this thing would just last for the next 6 months or even 1 year. And in the meantime, employees' jobs are at stake, are at risk. Why? Because if an employer does not have money to pay to his employees, what would be the consequence of that? Outright, the first option would be to lay off personnel. But then laying off personnel means people, employees and their families not having food on the table. And as what Attorney Jon have said, that reducing benefits, reducing work hours, or even flexible work arrangements, forced leave for that matter, are options that we need to take a look into, because these are things that can help the employer recover, and at the same time also help the worker maintain or have money in his pocket and food in the table for his family. The problem now is if all of this would boil down to, the inevitable, which is actually termination of employment. I was waiting kanina for a cue, but nevertheless, I'd like to share this, that in our jurisdiction, when you terminate employment because of severe business losses, the employer has no obligation to pay separation benefits. You just have to prove that you really suffer business losses. And in these conditions that we are right now, I'm pretty sure a lot of companies are losing a lot of money. And it's easy for employers to just let go of workers. But mind you, if you want to go back into business, you need people who have the skills, who have the talent, the dedication, those who know the rules of the game. So it's difficult to let go of these people. But nevertheless, if they let go of people, then the consequence of this letting go is quite dire, if I may say. Because there's that big possibility that people will be losing their jobs without getting even paid for separation benefits. That is why I would like to appeal to the good hearts of employers not to lay off personnel at this time. Maybe get into certain work arrangements that somehow would save jobs. Even if, for instance, one job, dalawa ang magtatrabaho nun, sharing lang muna in the meantime. One getting 50% paid, the other one also getting 50% paid. Because you cannot afford to have the entire month paid kung wala ka namang ginagawa. Instead of, losing a job when, say, somebody gets paid for the whole month while somebody else wala na talagang trabaho for good. So these are things that need to be considered, and it's not also, the appeal should not also go on only towards the employers. It should also go towards the workers. No, that we have to remember that this is the time for us to show to our employers na kailangan din natin magsakripisyo. We need to sacrifice. We need to feel the pain of the employers. They're not, they're not our mama that they will provide us everything that we need. We also have to shoulder part of this problem that we're facing right now. That's all, Karen.
Thank you. Related to what you mentioned early on, like for example, you're talking about the airline industry. There is a question here from Erica Aquino. How will the Department of Tourism help the hospitality and tourism sector, especially in their massive retrenchments? Anybody from the panel?
Rene, sorry, can you kindly repeat the question?
How will the Department of Tourism help the hospitality and tourism sector, especially in their massive retrenchments?
Well, it's hard to speak on behalf of the DOT. Maybe I think what we can do is just discuss this as part of at least supporting management and also the employees. What we can do to help employees who are suffering from maybe business reverses because of the COVID-19 crisis. So as mentioned by Attorney Noel, I think we should try to come up with ways to try to preserve the jobs of the employees. As much as possible, retrenchment or termination of employment should always be the last resort. If we can resort to reduction in benefits with the consent of the employees, because getting maybe 60%, 70% of the compensation or benefit is better than receiving nothing. So I think it's a give and take between the employers and the employees. Yung sa mga employers, wag naman sana mag-dismiss agad. Yung sa mga employees natin, maintindihan din natin yung sitwasyon ng employers kasi hindi lang naman din tayo yung nagsasuffer kung wala tayong trabaho ngayon. Kasi yung mga employers natin, wala rin namang kita ngayon kung sarado yung or walang operations.
May I interject, Attorney John, because I read in the papers this morning that the airline industry, particularly the Philippine airline industry, they have requested from government a subsidy of 8 billion pesos per month for them to be able to take off and save the industry. So I think if the government will react to that positively, then there's a better hope for our employees in the airline and tourism industry.
Karine, I think it should not be a one-way street lang eh. Government helps. The employers need to help as well, and the workers need to sacrifice. It's not uncommon in our jurisdiction na nagkakaroon ng reduction in benefits. If you recall, Attorney John, that case of Insular Hotel in Davao, when it was about to close and retrench workers, and the workers agreed with management to reduce their benefits, their entitlements in the meantime. Instead of losing jobs, they would rather receive less. That has been upheld by the courts. Even the case of Philippine Airlines before, when there was a reduction in, there was a moratorium in CBA negotiations, that was also upheld by the courts. My point is, everybody needs to sacrifice at this time. Hindi po pwede na iisa lang yung magsasakripisyo. Nobody has the right to demand something from anybody at this point in time because everyone is suffering. Government is losing money. It's not, GDP is down. Productivity is virtually zero. The same way as the employers. Workers are not making any money. And one friend says, messaged me earlier the other night, said, it's even more difficult we are even in a better situation, he said, because we have somehow some savings. There are employees who are on a day-to-day basis in terms of their subsistence. And these are the hardly hit people. But remember, the subsidy of government is not even addressed to those people. No? A lot of these wage earners, minimum wage earners, or even those that are still on the job yet receiving less, are not getting anything out of government subsidy. So everybody is bleeding. We just have to, take more pain, take more sacrifice, make more sacrifices, so that in the end, in the hope that we will be able to get up on our feet again.
Can I comment also? In relation to the airline industry, I must admit that we are directly hit, of course. If no one is flying, we cannot, nobody or no manufacturer of planes will accommodate our parts. So in align with our discussion today, can we appeal to DOT perhaps to come up with some guidelines also to allow tourism industry-related industries or companies, establishments, by coming up with some regulations and guidelines in allowing their operations so that at least movement of people will be facilitated such that it will not die as an industry. Because, the supply chain effect there is overwhelming. We're not just looking at the airline industry, but if DOLE is coming up with some guidelines on how to re-enter workforce, not in the regular industries, perhaps they can also come up with some guidelines for tourism-related industries.
Thank you, Rick. I now have listed 2 call to actions that we have to do after this webinar. Okay, I'd like to go to the next question coming from Charina Marquez. It was mentioned earlier that high-risk pregnancies belong to the vulnerable group. So, does that mean that those with normal pregnancies can go back to work once the ECQ is lifted? Thank you.
I'll take that question na lang siguro, Rene. So the interim guidelines have provided for this provision on higher vulnerable groups or most at risk, and yun yung mga naka-enumerate specifically. But I think we should not confine ourselves to that. So if we think it would be best for the employees, let's say a female employee who is pregnant but not necessarily in a high-risk pregnancy, if we think that it would be best for that employee to work from home and kaya namang mag-work from home, ipa-work from home na rin natin. Anyway, ina-encourage din naman ng DOLE na if feasible, continue pa rin yung work from home arrangements, which is also for the benefit, for the welfare and safety of the employees.
Thank you, Attorney Rowe. The next question is coming from Raquel from Cebu. as Attorney Jon mentioned earlier on the separation pay, is it mandatory that employers will include the monthly allowances that they give to employees on a regular basis to the computation of the separation pay?
Yes po, as long as these allowances are fixed and regularly given to the employees as part of their monthly compensation. So again, you should take take a look into your at your policies on the grant of such allowances. If there are conditions for the grant, like submission of receipts or proof that these are business-related expenses, then these are not really fixed allowances. But if there are no conditions for the grant and they are merely termed as allowances as for some other reason, like for tax purposes, then they should be taken into account when you compute the employee separation pay.
Thank you. Another question from anonymous attendee regarding work from home. What if the employee wants to continue working from home because he or she feels unsafe to go out?
Okay. Maybe I can answer that first. Well, first, you might want to take a look into your telecommuting policy or work from home agreement with the employees regarding the eligibility requirements or instances when the employees may work from home. In the absence of a mutually agreed upon telecommuting program or work from home arrangement, which expressly allows the employees to work from home, then yung general rule po, the determination of the place of work, these are all within the ambit of the management's prerogative. Because we should remember under the Telecommuting Act, including yung Dole Department Order 202, a telecommuting or work from home arrangement will be based on terms and conditions agreed upon by the parties. So therefore, an employee cannot unilaterally insist on such a work from home arrangement just because he or she might have the capability to do so. But I think may related question po dyan. Nakita ko rin dun sa ibang questions dun sa Q&A box natin. No? Ang related question, pwede ba nating tanggalin or dismiss yung mga employees who refuse to report to the workplace or insist on a work from home arrangement? Because as I've said, the general rule is that the determination of work arrangement or the place of work should be within the prerogative of the employer. Pero yung Department Order 1-20 na na-issue po noong January, coincidentally before this COVID-19 issue blew up, might provide some guidance also. So under the advisory, employees who fail to or refuse to work by reason of an imminent danger resulting from a natural or man-made calamity shall not be exposed to or subject to any administrative sanction. Although the advisory mentions only a natural or man-made calamity, given the government recognizes that we are in a state of a public health emergency and considers COVID-19 as a highly contagious virus, I think there's a room to argue that the current crisis creates a dangerous situation that might be cited by the employees, especially those with health issues and or comorbidities, to refuse to report to the workplace. I think as a practical matter, you should just seriously consider granting the employees request to be allowed to work from home, because this could at least create a win-win solution. Magiging productive pa rin yung employees, but at the same time, we can minimize the risk of a COVID-19 infection. So at least, I think for good measure, you should expressly provide the parameters of such a work from home arrangement by coming up with a clear telecommuting policy or agreement.
Thank you.
May I add to that, Rene?
Sige.
Well, another perspective of that issue, no? If you take a look at the labor code, there's a provision there on Article 89 that states that overtime work may be compelled by the employer if and when government declares a national emergency. Now, in this particular case, meron tayong declared na national health emergency. And there are certain workers who are required to render work by their employers. Who are this? Ito yung mga frontliners natin, yung food manufacturing, food processing, and all those that are needed to to continuously produce the needed logistics and supplies for everyone to survive. Now, the thing is, hindi na maialis na nandyan yung risk, nandyan yung hazards. The most important thing under our new OSH law is for the company to undertake mitigating actions to eliminate, to reduce the risk, and to provide PPEs necessary to protect the workers. So, in the end, yung pagtatrabaho can be compelled if and when sabi ng gobyerno, these are essential services. So people cannot just simply say, ayoko magtrabaho kasi may COVID. Pag hindi siya nagtrabaho, despite the fact that the employer has provided all the necessary mitigating actions to minimize the risk, no, or the hazards, or totally eliminate it, then I think he can be compelled to render work. Otherwise, he'll be held administratively liable. On the same token, now from ECQ, lumipat tayo ngayon sa GCQ, naging mas relax yung rules. And then there are already certain industries required, allowed to operate. If your employer falls within this allowed industries, tapos yung empleyado, notwithstanding na yung employer already undertook measures to ensure na the health and safety of its workers, ayaw rin magtrabaho, then the employee can still be held liable for that. Well, that's the opposite side of the story.
Yes. Related to that, that's on the side of the employee. There is a question here from Jeremiah Gomez. What are the responsibilities of an employer when an employee contracts the virus because he was exposed at work? Should employers subsidize hospital and medicine expenses on top of the HMO and PhilHealth coverage?
Ako, my personal take on this one is, first, empleyado is covered by PhilHealth because automatic na coverage if you're a worker and you're supposed to be contributing to it. PhilHealth provides comprehensive benefits for COVID-19. No? Pagkakaalam ko, there were even cases na umaabot ng million, but right now they're putting a cap to about 700,000. Now, the cost of treating the virus is actually part of the sabihin na nating risk that is being undertaken by PhilHealth in collecting the premiums from the workers and management. So ang nagbabayad ng PhilHealth premium natin, hindi lang naman yung mga empleyado pati yung management nagbabayad din. So if an employee, even if work-related yung kanyang illness, or doon na contract sa kanyang trabaho yung illness niya, for as long as there is PhilHealth coverage, essentially yung employer, wala siyang obligasyon to provide additional health benefits. Well, of course, it is really good, no? It is magnanimous on the part of the employer kung isi-shoulder niya yung cost. But then again, yung katungkulan na magbigay ng ayuda, magbigay ng benepisyo para doon sa kalusugan ng tao is already shouldered by the employer by contributing to PhilHealth. Kung work-related yan, meron siyang contribution to ECC. Kung merong aksidente or merong disability, merong SSS, meron ding ECC. Even death benefit, even retirement benefit. So all of these social and welfare benefits na tinatamasa ng isang empleyado, may contribution sa employer. And that contribution relieves him in a way of that obligation to provide the needs of the workers.
Thank you. There is a question here from anonymous attendee. I will read the question, but I will also reply to it para mabilis. There was an advisory about the non-inclusion of 1 month ECQ in the probationary period. What about now that the ECQ has been extended and now exceeded 2 months? I'd like to inform everyone that there is already a labor advisory number 14-A, supplemental guidelines of the non-inclusion of community quarantine period in the 6-month probationary period. Therefore, I'd like to jump because we only have 15 minutes to go. This is specifically addressed to Attorney John from Maria Corazon Sigismundo. Is a reassignment of posts or change in appointment amidst the prevailing pandemic legal? Can it be considered to have been done in bad faith?
I think regardless of whether or not there is a pandemic, yung pong rules on transfer should still generally apply. Ano po ba yung rules natin? A lateral transfer, that is a transfer from one position to another without any demotion or diminution of benefits, is allowed as long as it is entered into in good faith. There would be an issue if the transfer, as I said, would involve a demotion or diminution of benefits, because there could be a claim by the employee of a possible constructive dismissal. So in those instances, hindi po pwedeng i-insist ng employer yung transfer kung may demotion or diminution of benefits. Pero yung napag-usapan natin kanina, para nga as part of cost-saving measures, baka pwedeng pag-usapan na lang ng employer and employee para pumayag yung empleyado dun sa transfer which might involve a reduction in pay or a demotion, just to preserve the job of the employee.
Thank you. From L.A. Dionaldo, DTI and Dole only suggested the COVID testing for those employees in private sector coming back to work. However, LGUs mandate that business establishment to do so. Which one should prevail?
I think in that case, either Rene, kailangan natin i-reconcile yung directives ng LGU with the DTI and all the interim guidelines, no? Especially considering na we have limited testing kits. So I think kailangan ng clarification from LGUs, especially on how each establishments na i-impose or mandatory requirement nila na mag-purchase ng mga testing kits for the test of employees in their jurisdiction. We need specific guidelines siguro from the LGU if they're going to require that, and specifically on how each establishment will be able to comply with that. Because as far as the DTI and DOLE interim guidelines is concerned, it's not mandatory, it's only optional.
Rene, ano lang,
Yes,
dagdag ko lang kay Attorney Rob. I don't really want to, ayokong idiin to, but I think it's about time that we should be very clear about this. Yung pagtetest kasi to determine whether a person is infected or not, it's not the responsibility of the employer. It's the responsibility of government. Mga citizens niya yung nagkakasakit. And it is the responsibility of government to ensure na everybody is safe. At kung sino man yung may sakit, mabibigyan ng lunas yung kanyang sakit, yung karamdaman niya. But then again, we know government has limited resources. But with these limited resources that government have, ang tanong, sino bang uunahin natin? Meron lang ako kasing uncanny comparison OFWs, pagbalik dito sa Pilipinas, they get tested for COVID-19, automatic yan. I have nothing against OFWs. Magaling na mga tao yan, nagsasakripisyo yan. But hindi lang naman sila ang nagko-contribute sa ekonomiya ng Pilipinas. Between OFWs and the domestic workers working in the Philippines, yung mga tao nagtatrabaho sa Pilipinas, nagbabayad ng taxes yun. Yun, nagbabayad din ng PhilHealth yun. Automatic pa. So ang tanong, bakit hindi sila mabibigyan ng test? Ito kasi mga taong to are the ones who, sila yung mag-aahon ng ating bansa. Sila yung babangon ng ating ekonomiya. If you are to invest into something, you invest on those things and on those people na siyang magdadala sa iyo sa kung saan mo man gustong mapunta. The thing is, if we do testing now, ilan ba ang working class ng Pilipinas? Sabihin mo na nasa mga 40 million? I think that's the working population of the Philippines. Sa 40 million na yan, ilan dyan ang matitest natin? Matitest ba natin lahat yan? May pera ba tayo? Yes. Remember, government can afford to give 8,000 to how many? 20,000 families? Not only once, but twice ito. 2 buwan ito bibigay. No? Sana a portion of that, 1,500 is set aside para sa testing ng mga manggagawa. So that pagbalik ng mga manggagawa natin, maayos yung kanilang pangangatawan at tuloy-tuloy ang ating pag-ahon. Now, what will happen is if and when people don't get tested and we all go back to work, nobody will be safe. Nobody can be so sure whether there's going to be a second wave, a third wave, or whatever. But if and when all workers get tested, because it's a requirement of government for them to get tested, and it's part of the responsibility of government for them to get tested, then kahit papano, yung katabi mo manggagawa dyan sa LRT, yung katabi mo manggagawa dyan sa jeep or sa FX, at least kahit papano sigurado kayang taong yan maayos yan. Hindi ka mahahawaan yan. And I think that's the kind of confidence that government should give to us.
Thank you, Attorney Noel. The next question comes from an anonymous attendee, but this is of personal interest to me. Please expound on whether or not regular employees in NCR of senior age, ulitin ko lang, of senior age, 60 years and up, are free to report for work as they please. What restrictions apply?
Rene, we just have to follow yung guidelines ng IATF. Pag sinabi ng IATF na yung mga medyo may edad, may mga existing medical condition, sa bahay lang tayo. Kaya I mean, well, we're not saying na hindi kaya ng mga yan, but they're the most ito yung grupo na most vulnerable So kailangan protektahan din. Because pagka nagkasakit yan, marami din mga taong mahawaan sa workplace. And then one life lost is lost forever. Kaya mahirap na isugal yan. So, kung ako lang, kung kayang pagtrabahuin yan sa remote area, then doon lang siya sa remote. From time to time, baka kailangang pumasok, kailangang magpunta sa isang worksite, but siguro we have to adapt to the new way of doing things.
But there was a conflicting news report 2 weeks back wherein it said that seniors who are still part of the business can still report for work so long as they can comply with showing identification, etc., which now prevails.
I think
prohibition.
Go ahead, Attorney.
Prohibition. Attorney Jon, go ahead.
Yeah, I think ultimately we should rely on how the IATF will apply its regulation regarding seniors reporting to work. If I remember correctly, yung wording po ng IATF guidelines, hindi naman siya absolute. They say that as much as possible, seniors or workers who are at least 60 years old should not report to work unless they are really indispensable for the business. But ultimately, I think regardless of whether there's a prohibition or not, the employers generally have the obligation also to maintain the health and safety of its employees. Mahirap mag-generalize, of course, pero I think merong reason kung bakit binanggitin ng IATF dahil nga they consider the senior citizens as more vulnerable because of probably some health complication. It's the product of some studies of the IATF. But for every rule, there's of course an exception. And maybe as we apply the rules of the IATF, then we can probably explore those exceptions.
And
okay. Rick.
In our setup, we recognize the fact that these are vulnerable groups, but we also took into consideration the fact that some of these workers are so-called one-point failure in the operation. So we have to make a way by which they can still report to work if they cannot bring home the work. So it's on a case-to-case basis, making sure that they are safe in going to the work, from leaving their house, reaching the workplace until they will be able to go back. Okay, so I agree with Attorney John. The instruction of the IATF is not mandatory, so it's for the employers to take into consideration. There's also a study that indicates the seniors are actually more reliable as workers, so why not capitalize on them? So we are taking a benefit from both sides of the coin, so to speak.
Thank you, Rick. I love you. Okay, we only have 5 minutes to go. For those that we were not able to respond to their questions, we will forward all of your questions to our panelists so that they can give their responses, and we will request our professional staff to forward the responses to you. At this point, I'd like to request the panelists to come up with their parting words. Let's start off with Mr. Rick Bayao from the cold city of Baguio.
Okay, so after discussing a lot of things about returning to work and after the ECQ, hopefully, really, ECQ will end and we can move forward. The glaring reality for companies is to have an updated and aligned business continuity plan. This taught us a lesson. As we have observed, while a lot of companies have their BCPs, look at their procedures with respect to pandemic. I'm sure these are generally stated. What we need now are specific procedures to deal with this kind of situations. And considering that the situation will not go away the soonest, we should have an activated BCP throughout as we try to operate our businesses. Next, on the flexible work arrangement, perhaps DOLE can come up with more specific guidelines in the adoption of flexible work arrangements at this time, taking into consideration the real situations of a lot of industries. This is one way to protect the employees at the same time maintaining operations. We heard that in the BPO, if there are no clear telecommuting agreements, the compliance to data privacy has been compromised. So perhaps if, I don't know, if DOLE will come up with more guidelines to this aspect, okay? Compliance with certain existing laws that should be considered as we move forward flexible work arrangements, specifically working from home. And finally, in all these things that we have discussed, it appears that, as emphasized by Attorney John, communication to our employees is very important. Regular communication, keep them updated, because once the line of communication is open, you can readily access it. It's the best way to deal with any issues that will come out in the workplace. There is a mutual understanding between the employer and the workers as to what to do. While we have guidelines being published by government offices, it's still the best application of which is between the workers and the employers who know best what is the right thing to do in the respective organization. So with that, I hope let us not hope. This is a hopeless case. Let us move forward and let's beat COVID.
Thank you, Rick. Attorney Noel?
I think I've said a lot about testing, no? But summarize ko lang to very short yung discussion ko kanina. All of us need to sacrifice. One, government. Government has to invest on testing. Kailangan nating makakuha ng suporta from the government because the industry, the employers are down and out. Wala nang pera yan. Tapos ipipilit pa natin yung testing sa kanila. That's too costly. Employers need to consider also the welfare of the employees. Sana naman wag basta-basta na lang magtanggal, wag basta-basta mag-lay off. I-consider yung mga flexible work arrangements, part-time work for instance, leaves and all of those possible remedies to retain jobs. Kahit man lang konti lang yung matatanggap ng empleyado in the meantime, so long as meron, mas maganda pa yun kaysa sa wala. finally, workers need to sacrifice as well. Kailangang intindihin natin yung sitwasyon na yung gobyerno walang pera, na yung ating employers also are in pain. They're losing a lot of money. We also need to sacrifice. This is not the time for employees and workers to insist on their rights. Ito yung panahon na kailangan magkakaintindihan. Yung tinatawag nating tripartite na yan, yung gobyerno, yung manggagawa, at saka mga employers. Yun lang po.
Thank you. May I have Attorney Roe?
Thanks, CD. Siguro sa akin more on the practical side na lang, no? So with the continued ECQ or in transition from ECQ to a modified ECQ to a GCQ, I think with the extended community quarantine, we are all struggling. We have our own personal issues aside from yung mga financial issues natin. So with that, I think the key here is to stay strong. And I think with respect to employees and employers, talagang there's a need to be more understanding at this point. And crucial yung communication, open communication between the employers and the employees. And I think yung HR practitioners would be very important yung roles nila at this point in time. With that, let's keep safe and hang in there. Matatapos din naman ito.
Thank you, Attorney Roe. Last words, parting words from Attorney Jon.
Thank you, Rene. First of all, thank you everyone for attending, and of course the members of the panel. Well, from the legal side, of course, we are in an uncharted territory. You can expect the government will issue additional regulations when there is a decision to fully lift the ECQ, or as mentioned by Attorney Roe, to modify the ECQ or come up with a GCQ. So we should always monitor the guidelines in connection with the resumption of work. Although ang topic natin ngayon, legal aspects of reopening the workplace, I think we should also remember that not everything is in black and white. As mentioned by Attorney Noel, we are in a crisis. It requires every one of us to make a sacrifice. Sometimes we cannot just insist that, okay, the non-diminution of benefits rule will apply, so we should tell the employer not to reduce our benefits because this is our legal right. On the other hand, the employer cannot insist that the Department of Labor allows us to put employees on paid leaves without paying them at all. And the Labor Code also allows us to dismiss employees based on authorized causes. So again, sacrifice from both sides, not really, there could be a reduction in profits, reduction in compensation. But if we're all in this together, then we can survive this crisis.
Thank you, Attorney Jon.
Rene, nakamute ka yata.
Now, am I okay?
Good.
Okay na, Rene.
Okay, as I was mentioning, I'd like to thank our panelists today for your unwavering and total support to PMAP and helping the HR community and the general public with all of your knowledge. On the part of PMAP, we are going to push through with the call to actions that we heard today. Number one, we call to action on PhilHealth on the coverage regarding COVID and the mass testing, including the private sector, and on the Department of Labor to come up with the specific guidelines on flexible work arrangements and focus likewise on the protection of data privacy. And also, without missing, we will put in a word to the Department of Labor to allow, Department of Tourism, to allow airlines to be supported economically so they will restart their business and keep the economy moving. So you can expect all of that from PMAP. And with that, we would like to conclude our webinar this afternoon. A virtual applause to all of our panelists and attendees. Maraming salamat po sa inyong lahat and stay safe and healthy. Bye-bye.
Thanks, everyone.
Bye.
Philippines. People Management Association of the Philippines.